I'm Instructor Jason, one of the instructors at Krav Maga Self-Defense. So, we are all self-defense practitioners. What does that really mean? How far can we go defending ourselves, other people, and our property? I've mentally lined up this topic for the longest time, but recent news about a father in Queensland who used a baseball bat to chase away offenders who broke into his house to defend his wife and baby inspired me for this topic, or to bring up this topic. So, just a bit of a disclaimer here, the legislation we'll be talking about is specific for New South Wales. So, other states and other countries might have something similar, but it won't be identical. So, do the due diligence to research the legislation in your part of the world. So, Crimes Act 1900, New South Wales. In Part 11, which is described as criminal responsibility defense, on Division 3 of that part, which is labeled self-defense, you have these sections which relate to this topic. So Section 418, self-defense, when available. Section 419, self-defense, onus of proof. Section 420, self-defense, not available if death inflicted to protect property or trespass to property. Section 421, self-defense, excessive force that inflicts death. And Section 422 and 423, they're really more of when all this law applies. So we won't really touch up on that. So some of these I'll quote verbatim. The others will sort of summarize because it's really on that legal lingo that's very confusing and hard to understand. But okay, let's look at Section 418, 418, self-defense when available. So subsection 1, it says, a person is not criminally responsible for an offense if the person carries out the conduct constituting the offense in self-defense. So that's a bit of a bit of a mouthful, but an example of that with what I said earlier, that Queensland father, he had a baseball bat, confronted the intruder in his home. So someone broke into his home. We don't know what the intention was, steal property or commit other offenses, but he confronted that intruder holding a baseball bat, or showing the most likely showing the baseball bat, saying a few friendly words to that person to chase them away. So technically that offense would be more of intimidation, right? But since it was to protect himself, his wife, his child, or his property, that offense of intimidation doesn't apply because it was done in self-defense. So pretty much that's what 418 or subsection 1 of 418 says. So this applies to fighting, which is assault, maybe even causing actual bodily harm and all those things. As long as it's within that definition of you're protecting yourself, protecting others, and your property, it falls under self-defense. That offense doesn't really apply. And we'll have more specifics on that context, but it all revolves around that core concept. So subsection 2, I've put this pretty much in my own words a little bit to summarize things. So the condition is to defend yourself or another person, to prevent deprivation of yours or someone else's liberty, to protect property from unlawful taking, destruction, damage, or interference, and lastly, to prevent criminal trespass on any land or premises, where your conduct is a reasonable response in the circumstances as you perceive them. So these are sort of additional conditions where the offense won't apply as long as it's in the context of self-defense. Of course, easy defending yourself or someone else. This is a good one, deprivation of your liberty or someone else's liberty. So this might be sort of like a hostage situation, kidnapping situation type of, or more extreme ends of things, but sort of that area. You can sort of fight your way to gain back that liberty or to prevent the deprivation of which of yours and someone else. Protect your property, and we'll delve on this some more. But protecting your property from being stolen, destroyed, um, damaged falls under self-defense. You can do something about it. But we'll get into more details later. And of course, there's that trespass on your property or land or any premises. So, as that father did as well, that was his property, that was his home. And Section 419, 419, self defense, onus of proof. So this is also verbatim from the act that I've taken. The prosecution has the onus of proving beyond reasonable doubt that the person did not carry out the conduct in self-defense. So if it comes to a situation where you have had to do something or technically commit offenses to protect yourself, which is pretty much assault, intimidation. Of course, us, since we're training, it always falls into that assault fighting type of context that we automatically think of, or doing damage to the other person in order to defend yourself. If prosecution will try you, let's say this is the post incident, you have to go through court. Maybe it's not as straightforward. Somehow prosecution deems that there's something there where they deem, oh, he that wasn't exactly self-defense, and they put you through court. The is on them to prove that it wasn't self-defense. So it's all on them. Section 420, self-defense, not available if death inflicted to protect property or trespass to property. So as we looked at earlier, offenses don't apply if it's in the context of self-defense, which falls under that condition of protecting property. But for Section 420, if you kill someone to protect your property, that does not apply. All right, it does not apply. That it's excessive, it's overboard, and it's specified here. Um, yeah, that does not apply. So reading it verbatim is does not apply if the person uses force that involves the intentional or reckless infliction of death, only to protect property or to prevent criminal trespass or to remove a person committing criminal trespass. Protecting your property or someone trespassing or getting someone out of your property, make sure that you don't inflict death. Even here it says, even if it's reckless as an accident, that it doesn't apply. So something we have to consider. 421, self-defense, excessive force that inflicts death. So this is the really serious one. If it's gone to that really bad situation where you really had to defend yourself and it's either you or that person, and of course you'll choose you, right? Or someone you're protecting, a loved one, or that person, and you've had to um, take their life, this is where it applies. So I'll read a few. So subsection 1, section applies if A, the person uses force that involves the infliction of death, and the conduct is not a reasonable response in the circumstances as he or she perceives them, but the person believes the conduct is necessary. C, to defend himself or herself or another person. Or D, to prevent or terminate the unlawful deprivation of his or her liberty or the liberty of another person. The person is not criminally responsible for murder, but on a trial for murder, the person is to be found guilty of manslaughter if the person is otherwise criminally responsible for manslaughter. So that's a bit of a mouthful on that, but The first one we mentioned on the subsection one and the ABCD, those are sort of conditions, right? On the self defense, you apply um, while defending yourself, you actually kill the aggressor or take the life of the aggressor, whatever, a result of you defending yourself. And so these are the conditions. So, like B is interesting, where it says, although the conduct is not a reasonable response, but in your perception, that's what you needed to do. That was necessary, or you deemed necessary at the time. And you're doing that to defend yourself or another person, or to stop the unlawful deprivation of your liberty or someone else's liberty. So this is pretty. It doesn't get any more serious than this, really, in those situations, right? Um, so if all those conditions are quite straightforward, there's that term prima facie, right? The prima facie at face value. The prima facie case is pretty much straightforward that it was self-defense. You needed to do what you needed to do to survive, and that ended up in the aggressor being killed. Then that's self-defense. But if something's a bit off and somehow prosecution deems that it's not exactly straightforward self-defense, and they take it to court with a murder charge, then if that yeah, that they'll and it comes out as self-defense, you will not. The law says it shouldn't lead to a conviction of murder, but it's very fluid how the court or hearing goes. It may end up, if it satisfies some of the elements of manslaughter, you may end up with a manslaughter charge or conviction. But this is all very very case to case basis type of thing. It really depends on. You can't generalize a case like this. You have to. Each one is very unique, and you have to really analyze all that. So just touching up on that, quite interesting topic. But at least, right, we all train self-defense, KMG Krav Maga. We train to defend ourselves, but part of it is also the knowledge of the law of the land on how self-defense is actually in laid out in the law, and knowledge of this helps you a lot. Not just to take away the fear, but really understanding the situation, understanding the legal parameters and restrictions on how you act, and then you can adjust your training and response according to that. Early on in my craft training, I've met some lawyers, and I was very curious about this, and I've still very early on, and not as much knowledge and everything. So I'd really ask them, and I had this perception of, since I've asked them, I'll get some absolute answer, and they always said, "Oh no, we can't give you a straight answer on that. It's all arguable. Everything's arguable." And it's only now, later down the track, and seeing the court system and everything, that I do understand what they mean by arguable. So I thought before they were just covering their ass because, oh, Jason might do this, and he'll say this lawyer told me. But it really is. That's the It's not that, but it's really that's the nature of how it is. Everything will be argued in court. Everything will go through that. So we can. That's another topic we can bring up, just like a rough discussion on how court goes. But uh, yeah, it all depends on what you've done, what's happened, the results of what you did to defend yourself or someone else or your property, and yeah, and it will lead, under these restrictions and parameters, will lead to the result. Hopefully, very positive for you. But also, after all that, as our topic before that we discussed, you will, after all this, even though even if it's straightforward self-defense, you don't even have to go to court. You will still have to deal with the trauma that you've caused damage to a person or even have taken their life. You have to deal with that, or the trauma as well of going through court. That even though we shouldn't be too stressed about court, it's just how our land deals justice, and it's the only avenue for the truth and to settle things. It's still a stressful exercise to go through, and you want to, and that causes trauma as well. And there could be scenarios too where you did try to apply self-defense, but you could have you received damage yourself, or the person you're protecting has received damage that's a little more permanent and not as temporary. You're going to have to deal with that trauma as well. So just like the earlier topic, as we said about your choice, you will trauma will be there in the end, regardless of your result. So another thing to consider despite all this. And as always, to learn more KMG self defense techniques, train with us at KravMagaSelfDefense.com.au.